Greetings to my publicly held businesses, students. This pre-recorded lecture will cover our first reading assignment on piercing the corporate veil, which covers pages 612 to 633 of the casebook. And as you may recall, this was the assigned reading material for Tuesday's class, which was on April 7th, 2020. So before getting to the actual cases that examine the contours of actually piercing the corporate veil, I wanted to first explain in detail the differences between the business judgment rule and piercing the corporate veil. So we've seen this diagram before. I've used a comparable diagram when I first introduced the concept of corporate entities, and this diagram was helpful in distinguishing the various rights and duties between shareholders and directors. And so we know that the corporate entity is an artificial being that has its own rights and duties as set forth in the corporate charter. On the right side of this slide, we have the directors, and the directors are charged with managing the corporation under 141A of the Delaware Code. In doing so, the directors are protected by the business judgment rule. And we spent weeks upon weeks discussing the various ways in which this business judgment rule presumption can be effectively pierced. If in fact our business judgment rule is pierced, then the board members face personal liability for the poor decisions that they made on behalf of the corporation. And so the business judgment rule serves to protect our board members from liability. And the fiduciary duties that apply to directors run directly to this corporate entity for the most part, and to a limited extent, some of those duties run directly to the shareholders. So how is this different than piercing the corporate veil? So that moves us to the opposite end of this slide, where we have the shareholders, and we talked about the various rights and duties of shareholders, and that they have the right to vote. They vote for the nomination and appointment of directors during the company's annual meeting. They have the right to vote for major events such as mergers and acquisitions and reorganizations. So they have the right to vote, they have the right to sell their shares, and they have the right to sue for breaches of fiduciary duties. But they cannot effectively manage the corporation. And so this is related to the separation of ownership and control that we discussed at length, where the shareholders own interest in the corporation by virtue of their status as residual claimants to the corporation's assets. They're entitled to dividend payments, and of course they are beholden to the board in determining whether or not they will decide to make such dividend payments, whereas the directors manage the corporation. So as such, shareholders are protected by the limited liability veil that protects our corporate entity. And you can think about this in the context of a publicly traded corporation. And so if you were to own shares in Apple or Amazon, this large publicly traded corporation, it would be completely unfathomable to be liable as a shareholder. Perhaps you purchased those shares through Robinhood or another intermediary. It would be completely unfathomable for you as a shareholder to somehow be liable for the wrongdoings of this corporate entity. However, under certain circumstances, which we will begin discussing today, if this veil of protection that actually protects our corporate entity, is pierced somehow, then the shareholders can be personally liable for the wrongdoings of the corporation to third parties. So the business judgment rule, when it is effectively pierced, it very much has to do with wrongdoings to the corporate entity and the shareholders. Whereas when the corporate veil is pierced, it is pierced due to wrongdoings caused by the corporation, suffered by third parties. And so who are these potential third parties? So one category that we'll review today is creditors. Okay, so creditors are not protected by fiduciary duties to the same extent that shareholders are protected. And so in the event that a corporate entity runs out of assets, the creditor may not be able to receive its final payment obligation from the corporation. So under certain scenarios, the creditor would likely seek to pierce the corporate entity veil of protection to hold the shareholders personally liable for the debt. Another category of potential wrongdoing would be tort claimants. And so to the extent that our corporate entity is producing products that are harmful to the environment or to consumers, or to the extent that the corporation is engaged in activities that harm individuals or that harm their property, to what extent, right? And again, perhaps the corporate entity is completely out of assets. To what extent can we hold shareholders directly liable for those claims? And before moving to the next slide, I should also briefly mention that this piercing the corporate veil doctrine never applies to publicly traded corporations. And when we get to the Fletcher test, it will be much easier to understand why that is the case. Because in order to pierce this corporate veil of protection, there has to be some element of control by the shareholders. This level of control does not happen with respect to a large publicly traded corporation because the shareholders are geographically dispersed all over the country, perhaps even globally. So they're not going to have the requisite level of control in order to pierce this corporate veil of protection. And so that brings us to our next slide. And so the next series of slides actually covers the 3 assigned cases for this reading material. So this first case, Consumers Co-op versus Olson. And so what happened in this case is my first question. And here's a very brief description of the facts provided in this slide. So here we have a close corporation. It is closely held by this family where Chris Olson is the majority shareholder and president and the general manager of ECO. His parents own the remaining shares, and they served as the other directors and officers. And the initial capitalization of this closely held corporation was a mere $7,000. In my corporate finance course, we talk at length about what this concept of capitalization actually means. And a corporation can be capitalized through shares, which was the case in this particular opinion. It could be capitalized through a debt offering. It could be capitalized in a number of other different ways, through preferred stock offerings, for example. But here, the company is solely capitalized by these by the selling of shares. In exchange, they received $7,000. And so at a certain point, ECO could not pay its debts. In 1982, the shareholders' equity account was negative $62,000. In 1984, the account was approximately negative $190,000. And so As a result, ECO was in an unfortunate position where the company was not able to pay its existing debts. And so Consumer Co-op, one of ECO's creditors, sought to pierce the corporate veil of ECO to hold Chris and Jack Olson personally liable for the debt. And so here, clearly the issue is whether or not the corporate veil could in fact be effectively pierced. And so what is the test that the court uses to evaluate whether the corporate veil should be pierced? And here the case, as well as the initial notes of this assigned reading material, introduces us to the Fletcher test. And so this is the test that I want you all to be responsible for. You'll see different variations of this test cited to different cases. The application of this test depends on the jurisdiction. The application of this test is also a highly fact-intensive inquiry. But this is the test that I want you to be responsible for. So pursuant to the Fletcher test, a court will pierce the corporate veil when the plaintiff proves that, number one, the defendant shareholder dominated and controlled the corporation so that the corporation had no mind of its own. Number two, the second prong, the defendant used this control to commit fraud or wrongdoing. Last but not least, the control and the breach of duty were the proximate cause of the plaintiff's loss or injury. And so we'll spend this class, as well as our next class, dissecting each of these three prongs. And so this first prong, were the Olsons in control under the first prong of the Fletcher test? How do we evaluate this prong? How do corporations think? How do corporations have a mind of its own? And so this is an interesting question because corporations are treated as artificial beings under the law. So they do have mechanisms for making decisions and thinking, even though they are not flesh and blood human beings. And so corporations make decisions through corporate formalities, such as having an annual meeting for the company where directors are elected. Corporate formalities include keeping the assets of the corporation as well as the directors separate. Corporate formalities include documenting each board meeting with written and filed minutes. And so corporate formalities really provide a mechanism for companies to think and for companies to make its decisions. These formalities document the exercise of rights and duties that attach to shareholders and directors. And so when you see these formalities being appropriately exercised, we start to see something that looks more like corporate democracy, where there are these checks and balances between the powers of shareholders and directors that are effectively being weighed, as opposed to a monarchy, where instead you have a single shareholder, that is effectively controlling all of the affairs of the corporation without following any corporate formalities at all whatsoever. Now, we'll get to this point later. One may argue, and I'm sure that one of you all would have asked this if I was actually giving a live lecture or a lecture through Zoom. Presumably you would have asked, but Professor, what about a close corporation where oftentimes there's a couple of shareholders, and those shareholders are also serving as directors and officers? Perhaps corporate formalities aren't quite as important. And so courts tend to agree with that assessment, that in the context of close corporations, while it is essential that they do what they can to comply with all of these corporate formalities, perhaps we should give them a little bit more leeway. Okay. In the second bullet, if no corporate formalities, then the corporation has no will of its own, and it is merely being controlled and used by shareholders as an alter ego to effectuate the wrongdoings that would be implicated in the second prong of the Fletcher test. So in the context of this case, one could argue, as you saw in the opinion, that that because this company, although the directors met frequently, they did not keep any sorts of records. They didn't keep sufficient records with respect to these meetings. And so, yes, right, you could argue, yes, these shareholders utilized the corporate entity as its alter ego to effectuate wrongdoing. However, and this is where the court agreed, you could argue, no, they didn't exercise this level of control. There were proper corporate formalities that were followed. Stock was issued, officers were elected, business was undertaken in the corporate name, board meetings were held. While no records were kept of these meetings, the board did meet relatively frequently, actually. There was no commingling of personal and corporate assets. And here, this is where the court clarifies, particularly under Wisconsin law, that there is more leeway provided to close corporations. Okay, and here the court also discusses this interesting fact where Chris Olson did infuse some of his own capital into the company in an effort to resuscitate the company because it was doing so poorly. And so one could argue that this strays away from corporate formalities, but here the court is saying, technically, yes, but this is something that we actually like to see. It kind of demonstrates that these shareholders / directors / officers were not engaged in wrongdoing and that they were actually trying to help the company to improve its dire financial situation. So what about this whole concept of undercapitalization? Where does this fall under the Fletcher test? What is it? When is it measured? In a live class, I would separate each of these questions and have a more robust discussion in terms of how the court answered and assessed these questions. But for purposes of this recorded session, I am going to go ahead and lump these all together. And so the second prong of the Fletcher test, this is the prong where the defendant used the control of the corporate entity to commit a fraud or wrongdoing. And so here we need to figure out the kinds of frauds and wrongdoings that would rise to the level of actually violating this particular prong. And so undercapitalization is actually an example of the kind of wrongdoing that this doctrine is concerned with. And so undercapitalization examines the extent to which shareholders infuse a sufficient amount of capital into the venture to ensure a reasonable chance of success and to pay its creditors. ECO's initial capitalization was $7,000. And so when is capitalization measured? It's actually measured at the outset of the creation of the venture, when the venture was initially created. And so because it is measured within this limited time frame, the court found that ECO was sufficiently capitalized at this time frame. And the court will not reassess capitalization unless the corporation somehow changes the scope of its business. And so what does this potentially mean? This could mean that the business has expanded to other geographic regions. It could mean that the business merged with another company. It could mean that there was a significant reorganization of the business. It could mean that the company acquired another company. And so in this case, this could have potentially been an issue. So although ECO did potentially change the scope of its business in July 1980, it didn't matter. This was a moot point because of some of the things that our creditor did. And so Consumer Co-op, in terms of this waiver argument, they assumed the risk of loss inherent in dealing with a thinly capitalized corporation. And they even went against their own credit agreement. There were clauses embedded in the credit agreement that specifically provided like, look, Consumer Co-op, you need to cease extending credit to this company if the company is unable to pay its debts within a certain period of time. ECO was clearly in violation of this provision, but Consumer Co-op continuously extended additional credit. Therefore, this creditor waived its right to assert undercapitalization as a grounds for piercing the corporate veil. Estoppel is a comparable argument where Consumer Co-op was estopped from bringing this claim because its actions actually induced ECO, the company, to accept further credit in reasonable reliance on consumers' lack of concern for ECO's undercapitalization. And so estoppel is distinctive in that we're assessing the extent to which the creditor induced reliance with respect to the company. Okay. This brings us to our next case. KC Roofing Center versus On Top Roofing Incorporated. So what happened in this case? What was the relationship between the string of corporate entities created by the defendants? Gosh, it would have been nice to have a timeline here. Here we only had Russell and Carol Nugent, a husband and wife team. They were the sole shareholders and officers and directors of On Top Roofing Incorporated. So this is very characteristic of a close corporation structure. In 1977, On Top was incorporated, engaged in a roofing business until August 27th, 1987. Immediately thereafter, the Nugents organized a new corporation, R&R Incorporated. Wait a minute. Then sometime in 1988, the Nugents formed a third corporation, RLN Construction Incorporated. So what is going on here? Why are they organizing this series of corporate entities? The Nugents maintain that on the formation of each successor corporation, the predecessor corporation went out of business. This is another integral component to this fact pattern. However, according to the two creditor plaintiffs in this case, they were led to believe that they were contracting with On Top, even though pursuant to the Nugents, On Top was already closed, shut down, no longer in operations. Okay, so KCRC, pursuant to this creditor, On Top bought roofing supplies on credit from KCRC from April through August of '87. And then, according to the Lumbermans, On Top or R&R bought supplies from the Lumbermans in November 1987. When during this time period, clearly On Top should have no longer been in operations. So, what is the issue being decided in this case? The issue is extremely similar to the last issue in our previous case in that we are seeking to determine, the court is seeking to determine whether the corporate veil should be pierced, making the Nugents personally liable for the corporation's debts with respect to these two creditors. And so, although the court did not neatly apply the Fletcher test, I'm going to go ahead and apply the Fletcher test to all of the cases that we will be reviewing on this chapter. And so the first prong of our Fletcher test, which deals with the extent to which the shareholders controlled the corporation so that it had no mind of its own, here the court found quite easily that Russell Nugent, and not his wife, completely dominated and controlled the corporation to effectuate the wrongdoing. There were even statements that were made, which we'll get to later, where he admitted that he completely controlled the corporation. The court didn't directly mention this, but there didn't seem to be any sort of corporate formalities that were followed. And so here there's a clear case of control. That brings us to our second prong. What was the essence of the wrongdoing here, right? Like, who cares? What's wrong with setting up all of these various corporations? According to Nugent, he simply wanted a fresh start. He was within his rights to engage in this process of closing one entity and opening a new one, and so perhaps he did nothing wrong. But here we have a clear issue of undercapitalization, where Russell Nugent was knowingly taking on additional debt, even though he knew that his underlying corporations did not have sufficient assets to cover these obligations. There was also a potential illegal dividend, and the court does not characterize it in this manner, where there was a portion of the opinion which talked about how the Nugents charged the corporation rent of close to $100,000 per year. And they couldn't explain. They couldn't explain why they would do such a thing. I mean, think about it, $100,000 a year. This is about maybe $8,300 or so of rent per month. They had a really small shop. They didn't seem to have many employees, right? And so why would they charge such an excessive amount for rent, as well as their salary? So perhaps you could characterize some of these payments that they effectively received themselves as potential illegal dividends. Okay, and then this third potential category of wrongdoing, leading creditors to believe that OnTop was still in business. So this was Luberman. They thought that they were contracting with OnTop, and they thought that due to some of the actions of the Nugents, or Russell Nugent in particular, and that they still had flyers with OnTop's name, sheets, store signs, truck signs. He would try to argue that the name was slightly different, and so perhaps he was in compliance with this law. But they led the creditors to believe that this company was still in existence, that they were contracting with this company, even though it clearly was not the case. Okay. And so our last case deals with the category of wrongdoing related to torts. And so before getting to this last case, right, and then our previous two cases dealt with wrongdoings to creditors, or potential wrongdoings to creditors, where the corporation is extending credit and taking on additional credit, even though they do not have sufficient assets in order to be able to pay these obligations. And so there's this overriding question about whether or not the shareholders should be personally liable. And so this entails piercing the corporate veil in the context of contractual rights, or enforcing contractual rights. So torts, this is slightly different, although we will still apply the Fletcher test in determining whether or not to pierce the corporate veil. And so before getting to our Western Rock case, I wanted to just make a few clarifications and revisit torts. for a very brief moment. And so, in thinking about torts and vicarious liability, our corporation under agency law is essentially the principal, and the corporation's employees would be considered its agents. And so the corporation is potentially liable via vicarious liability to tort claimants that are harmed by its employees. And so you could envision a number of scenarios where this would arise, such as a company has an employee, and perhaps the employee, within its scope of its duties and obligations to the company, maybe the employee is a photographer, maybe the employee then drops the camera onto someone's head, causing injuries. If the employee was acting within the scope of its duties as an employee to the company, then the company could be vicariously liable. However, the corporation is not considered an agent of shareholders. Shareholders are not employees. So shareholders are not vicariously liable for the forms, torts, or debts. Okay? This is different than piercing the corporate veil. Okay, so if in fact a tort claimant is seeking to make shareholders liable, and assuming that our shareholders are not employees of the company, they would have to do so by piercing the corporate veil. This is different than vicarious liability, which you learned in torts, which I know was a long time ago, and even longer time ago for me. But I did want to make this distinction because I think it's easy to confuse the two conceptually. And so that brings us to our last case, Western Rock Company versus Davis. And so the first question, what was the nature of the harm caused by Western Rock Company to third parties? And so here the harm was pretty clear in that the company was engaged perhaps in negligent blasting activities in a rock quarry. These blasting activities seem to cause significant damage to plaintiffs, right? These are our third-party tort claimants' homes and their business properties. And so here the issue is whether Fuller and Stroud, as shareholders, should be personally liable for these third-party damages by piercing the corporate veil. Should they be personally liable? And so before assessing this question, before applying our Fletcher test, the first essential question is, what roles did Fuller and Stroud hold within the company? And so Fuller and his family, they owned 50% of Western Rock through this entity called Machinery Investment Corporation. So Machinery Investment Corporation actually owned 50% of Western Rock stock, but Fuller and his family completely controlled Machinery Investment Corporation. Stroud and his wife owned the other 50%. Stroud was the president, Fuller was the director. And so in applying tort law principles under vicarious liability, who would be liable for these damages? Under vicarious liability, Western Rock would be liable. But as we saw when we evaluated this fact pattern, Western Rock did not have any remaining assets. And so the tort claimants, of course, had to seek remedies or attempt to receive remedies through piercing the corporate veil and going directly after the personal assets of Stroud and Fuller. And so why is Fuller and Stroud arguing that they should not be held liable? How is this the case? How is this possible? Well, Fuller and Stroud, they're saying, gosh, we weren't the employees. We weren't the employees. We were far removed from these blasting activities. We weren't the ones actually operating the equipment that allegedly caused the damages to these tort claimants' homes and properties. They didn't actually take part in the operation of the quarry and or the blasting activities. They also alleged that there was insufficient evidence that the blasting activities proximately caused the alleged damages. There wasn't really that much discussion on this front, but this was another component of the defendant's arguments. And so this brings us to the first prong of the Fletcher test. Did the defendant's shareholders dominate and control the corporation so that it had virtually no mind of its own? And here, Fuller owned, so the court ultimately held that the shareholders did in fact control the corporation so that it had no mind of its own. One interesting component in making this assessment to the fact pattern was that Fuller owned all of Western Rock's equipment, making such assets available to the corporation via leases. I thought that was fascinating. Fuller then stated, "Well, you might say that I was their father confessor. Everything they did, every damn piece of equipment they had, every bank loan they had, and everything else, I was the man behind it. So, I do it all from that standpoint. I furnish them with the money." So he seems to be implicating himself in assessing the extent to which he controls this company. Fuller was informed and participated in all key business decisions and was in touch with Stroud, who was the supervisor, at least 5 times a week. Okay. And so what about 2? Did these defendants use this control to commit fraud or wrongdoing? Here, the court does in fact conclude that Fuller and Stroud had knowledge of the blasting activities. Fuller and Stroud tried to argue that they had no knowledge of the blasting activities, and they weren't aware of the blasting activities until much later after they actually occurred. The court found this argument completely unfeasible. They didn't buy it at all. So the court ultimately concluded that yes, Fuller and Stroud had complete knowledge that these blasting activities were occurring. There was also a wrinkle where there was no insurance that could cover the losses suffered by these tort claimants. And so there was no new money available to these claimants to be able to repair their homes, even though the activities of the corporations effectively caused the damages to their properties. And of course, Western Rock encounters financial difficulties. And so even after all of this, right, no insurance to cover the losses, Western Rock is experiencing financial difficulties. It's completely unfathomable that they didn't have any knowledge that this was occurring. So after learning about these blasting activities, they continued for an additional 4 months. So the court holds yes, right? Fuller and Stroud, you used your control to effectuate this wrongdoing where you had knowledge that it was occurring, there was no insurance to cover the losses, and even after you had the knowledge, it continued for an additional 4 months. And so this prong of the Fletcher test is easily met. With respect to this last prong of the Fletcher test, did the control or wrongdoing proximately cause the plaintiff's losses and or injuries? Here the court concludes clearly yes. You can envision other potential causes to the damages of the plaintiff's homes. So was there a severe storm, for example, that could have damaged the plaintiff's homes? Were the plaintiffs did they somehow contribute to the damage of their homes through some sort of activity that they were doing? Like maybe they remodeled their home to cause comparable damages or to cause the damages complained of. And so this kind of brings us back to torts and trying to evaluate whether or not the wrong doing was the proximate cause of the plaintiff's losses and or injuries. And so here the court says clearly yes. And so in applying our three prongs of the Fletcher test, the court held that the corporate veil is effectively pierced. And so this concludes our first lecture on piercing the corporate veil. We will continue with this discussion on Monday, which I think is April 13th. Instead of doing this pre-recorded format, and I will email you all about this, I intend to do a Zoom session, and I know that I owe you all the remaining reading assignments for the last 3 classes. With that being said, please let me know if you have any questions or concerns about this lecture or about the class, and I am looking forward to seeing you all on Monday.